What happens if I die without a will? We often talk about the need to make a will. Less discussed is what happens when someone passes away without one. In Victoria, if someone dies without a will, they are said to have died intestate. In this case, the laws concerning an intestacy apply. These are a set of rules that outline, according to a rigid government formula, what is to happen to the deceased's estate. If the deceased left a partner, all of the estate will go to them. If the deceased also left children from another relationship, some of the estate may also go to them. The deceased's next of kin will have to apply to the Supreme Court for what is called a grant of letters of administration. Now, all of this can be okay. It can also produce considerable unintended problems. At a basic level, you don't get to choose who receives your estate, nor can you select the person you wish to be responsible for carrying out the terms of your will. With a will, the person the will maker has selected to carry out the estate is already known. But if there's no will, the person with the greatest entitlement to the estate usually applies for the grant of letters of administration. It's not uncommon for a dispute to arise at this point, because numerous people believe that they should be appointed as administrator. That's the equivalent job to an executor where there's no will. This in turn can lead to delays while these matters are sorted out. An example of this can arise where a child dies before a parent, and the parent, being the person with the greatest entitlement to the child's estate, is required to apply for the grant of the estate of their deceased child. Several recent cases we've had involvement in involved elderly parents of children. Some of these parents were in care facilities with dementia, but were selected under the government formula to act as the administrator in a child's estate where that child had not left a will. Another associated problem with no will being made that we see quite regularly here are elderly parents who suddenly become beneficiaries under an intestacy of a deceased child. This can create a problem for the parents, as receiving part of their child's estate may disqualify them from receiving the age pension or other government benefits. In summary, if you die without leaving a will, many things that were certain become far less so. This in turn can lead to disputes and delays in implementing an estate.